Hello, welcome to the Ukrainian Studies Organization at Indiana University. I am Ani Abramyan, and joining me today is Natalia Shpilova-Said. We are delighted to welcome our guests, editors and contributors of the volume that has been recently published, titled Regional Diversity, Decentralization and Conflict, The Case of Ukraine. Our conversation today will be based on this volume, and I would like to introduce our speakers. Today we have six. Maryna Rabinovych served as editor of the volume, is an assistant professor at the Department of Public Policy and Governance at the Kyiv School of Economics. Maryna Rabinovich's research interests include international and EU development policy with a focus on political development and fundamental values, rule of law, democracy, good governance, international and EU trade policy, EU external relations and their legal regulation, as well as actual issues pertaining to Ukrainian politics and law, such as the reform of decentralization and conflict settlement. She publishes her works in international peer-reviewed journals such as East European Politics, Brill Open Law, Journal of Contemporary European Research. Next, we have Hanna Shelest, also served as an editor of the volume, who is the Security Studies Program Director, Editor-in-Chief of UA, Ukraine Analytica, and Foreign Policy Council, Ukrainian PRISM. Prior to this, she served for more than 10 years as a senior researcher at the National Institute for Strategic Studies under the president of Ukraine Odessa branch. In 2014, Hanna Shelest served as a visiting research fellow at the NATO Defense College in Rome. Previously, she had experience in PR and lobbying for government and business, as well as teaching at Odessa National University. Yaroslava Barbieri is currently a doctoral researcher at the University of Birmingham, UK. She has collaborated in a research assistant capacity with a number of UK and Ukraine-based think tanks. Andriy Nekolyak is a political science PhD student at the University of Tartu in Estonia. Andriy's doctoral dissertation is concerned with examining the patterns of memory politics and memory loss emergence in Ukraine, Poland, and Estonia. Nadia Koval is a foreign policy analyst and researcher currently with the Foreign Policy Council Ukrainian PRISM. In the last few years, Nadia has been researching different aspects of how the Ukrainian crisis is perceived and interpreted by politicians, pundits, and the general public in a number of Western countries. Finally, we have Tomasz Lachowski, who is a doctor of law, legal researcher, and the chair of international law and international relations, Faculty of Law and Administration, University of Lodz, Poland, working in the field of international law, human rights, and transitional justice. We will start with the presentations. Please submit your comments and questions via the Q&A option, which you can see at the bottom of the screen. And our guests will address these during our Q&A session. Welcome, guests.
Hello, and thank you for hosting us today. So as I understand, you're giving the floor to us as for now. Yes. Thank you. So we're glad to have this opportunity to talk about the book that's been just recently released and now is available for purchase. But it seems to me that as currently there are so many new books, it's always better first to know what it is about. And as you're having more and more books about Ukraine, it's definitely very important to tell in the beginning what is the biggest difference of this book, maybe from others, that can be in your mailing list. So the book that been just published, it is the result of 2 years work of the big team of researchers from several countries. Some of them of Ukrainian region, some of them of other countries who joined us, and even the Ukrainian region authors are currently working with the best universities around, not only Europe, but even Australia. So we tried to present quite a wide view on the topic that we've been discussing. And in the beginning, probably the best to explain what is the difference is the title of the book, because all of us are reading articles in media and think tanks, the new books appeared about the Russian-Ukrainian conflict, about the events in Ukraine, Crimean annexation, but usually it is just from the point of view of international relations or international security. Here, we really tried, by the efforts of our authors, to look at the more complex picture, to some of the myths that are half myths, half based on the real situation, but which is misinterpreted or manipulated sometimes in the ways of propaganda by the conflicting parties. So we've been looking to the regional diversity of Ukraine, what is a natural process due to the history. And our authors demonstrated it both in terms of the ethnic diversity and the regional diversity due to the historical reasons, to the political preferences of the different groups of population. But then we looked to the problems of decentralization, and we used this term, not the federalization, because as our authors, and today we have Nadia Koval, who perfectly described it in her article, and she would definitely tell more about this, how behind the terms we have the completely different ideology and the perception of the problems. So we are talking about the decentralization, both in positive and negative meanings, of what it can bring to the Ukrainian society with all this diversity, or what risks it have for the future, or how it is manipulated. And all of these have brought us to the last word of the title, the conflict, because definitely we're analyzing all the issues that we have on the, let's say, with the conflict on the background, if you can say it like this, because the conflict always is coming in front. But we should analyze each of the issues of decentralization, of European integration, of regional diversity, with the shadow of the bloody conflict that is happening, first of all, in the eastern Ukraine due to the Russian aggression, but also because of the illegal annexation of Crimea by the Russian Federation. So in this case, and we put it just the case of Ukraine, we didn't want to name it the conflict in and around Ukraine as the OSCE is naming. We didn't want maybe to name it just Russian-Ukrainian conflict, because we looked here not only as a 2014 and till the nowadays, but the wider, what is the conflict potential can be because of the diversity and decentralization issues. So within this book, you would find maybe not the answers to all the questions, but definitely a lot of the new interesting information about the situation. You would find the deep research and explanation of the certain processes happening now and that can influence the situation in the future. So for me, what is good in this book, that it gives you not only the perspective of the past or the description of the present, but it gives quite a number of thoughts about the perspectives, about the future, about what issues we need to follow in the future, but also maybe certain lessons to other countries or other regions in the world. I will make a pause from my side and will be glad to give a word to my wonderful core-editor who managed to organize all our authors in one cohort, in one book, Maryna Rabinovych.
Thanks, Anna. I think it was so comprehensive that now it's difficult to find what to add. Just a short piece of thought from my side is about the academic activism point that I liked from our previous webinar when we were first presenting the book. We were asked whether the book can be considered a piece of academic activism, and first I was astonished by this question and trying to find out in my mind what it can mean. But then apparently, as I started thinking, yeah, it's a piece of academic activism because we gather together in order not to just deliver some new knowledge, but also in order to present possible threats, to give some warnings, some red lines, and to draw some future prospects as regards decentralization reform. And also, as we get quite many requests regarding the book, regarding writing some short pieces about decentralization now, we can really see that the book gave an impetus to discussing the nexus between decentralization and conflict resolution. And this nexus is something that was really overlooked before in the studies of both decentralization on the one side that was merely addressed from some economic, financial, political perspectives, but not so much from the perspective of conflict resolution, and on the other hand, the conflict resolution studies that merely addressed conflict and the way it was settled. It was being settled, let me say, in terms of the international peace talks. So what we do, we really try to bring together the domestic and the international levels and show an extent to which these conflict constellations are complex, and we can never say the conflict is just an international one or a domestic one in the world where there are no more borders except for the virus cases. Plus, what we try to do is to really zoom in on the decentralization efforts and distinguish them from any other discourses that are being promoted by foreign actors in Ukraine. Plus, what we do, we look at decentralization broader, more broadly than just in terms of conflict resolution, but try to see its more implicit effects that impact the conflict, such as, for instance, effects on democratization, on modernization, on European integration of Ukraine. And this phenomena can also, in turn, impact the conflict and Ukraine's resilience and attractiveness for people who are currently on uncontrolled territories and still haven't maybe yet made a choice whether they would like to live in Ukraine after Ukraine reintegrates these territories, hopefully. Also, the local elections 2020, just in 10 days, will give us some new answers, and I hope we'll come up with new policy briefs, with new research based on this book, and deliver new knowledge and new answers and new policy recommendations. So shall we proceed with our presentations for now? So the first thing we start with, traditionally already, is regional diversity. And now I'll pass the word to Andriy in order to speak about the language issue in Ukraine and the role of the Constitutional Court in the war over language in Ukraine.
Hi all, thank you organizers and Maryna for inviting me to speak today. I will be very brief in making the case about my contribution to the edited volume. For Maryna and Hanna's book, I contributed with a chapter entitled Navigating Ethnopolitical Disputes, Ukraine's Constitutional Court in the Tug of War over Language. In this chapter, I and my co-author aim to profile the evolution of Ukraine's language policy and legislation and to examine when and how Constitutional Court of the country was dragged into decision-making about language politics in Ukraine. In the context of our today's event, I believe the chapter makes two particular contributions to the scholarship in Ukraine. Foremost, on the legal side of things, it pays attention to juridical component of language policy in Ukraine. So far, I believe this was not addressed to the extent it could have been. And in this regard, scholarship explored the topic very sporadically. For instance, Volodymyr Kulik mentioned separate decisions of the Constitutional Court in his writings about language policy in Ukraine. Bill Bowring analyzed Ukraine's obligations under international law in the domain of language use and minority protections. More generally, scholarship on courts and language, courts and politics and society is quite scarce in Ukraine and about Ukraine. And here, where my contribution stands out, it goes into the analysis of constitutional adjudication of language politics. It tries to conceptualize the court's language jurisprudence, and it aims to deal with such questions if the for instance, if the scholarly discourse about judicial activism somehow relevant or not for discussing the court in how it deals with issues of language diversity in Ukraine and with different language appeals. Moreover, on the politics side of things, the chapter examines political dynamics and constellations of political agents behind language politics in Ukraine. In particular, I discuss how various Ukrainian language-minded and Russian language-minded politicians tried to institutionalize Ukrainian language more or push for greater accommodation of Russian, and how overall judicial politics came into play with language politics. And in this context, I made particular claims that the successes or failures of language warriors in using the avenue of constitutional adjudications was dependent or is dependent on adopted litigation strategies. Whenever plaintiffs ask to rule over constitutionality claims, they almost always failed, except of a handful of cases on constitutional procedure, where constitutional procedure was involved. And on the other hand, curiously enough, whenever plaintiffs sought to official interpretation of legislations from behalf of the court, they quite often got huge payoffs in terms of actual empirical outcome provided by the decision of the court. And this finding provides a nuance into a broader nuance into understanding the relationship between Ukrainian politics, constellations of Ukrainian politics on one hand, and the pattern of judicial politics in Ukraine on the other. This is all from my side. Thank you.
Maryna, we can hear you.
Yeah. Now you can hear me. So now, for now, we are finished with regional diversity, and what we speak about next is the conflict. And therefore, I would like to pass the word to Tomasz Lechowski from the University of Łódź, who shall speak about the international aspects of reintegration, the topic he worked on in terms of our book.
Thank you, Maryna, and thank you, the organizers, for the invitation. It's a privilege for me to be here tonight, at least tonight in Poland and in Ukraine, with you. Yes, my chapter was devoted to the issue of the reintegration of Donbas, analyzed through the lenses of the language of international law and human rights, also with some very crucial point of adopting or trying to shape the comprehensive strategy of transitional justice in Ukraine in terms of the reintegration of Donbas. First of all, it was the case of my chapter, but of course we have to remember about the situation in Crimea that also have to be considered in that terms of deoccupation and reintegration of the occupied territories into Ukraine, hopefully, as Maryna said, in the near future. As I told you, I'm international lawyer, so I have analyzed these issues from the point of view of international law, and of course we all know, but many viewers, many listeners, especially biased by the Russian disinformation propaganda, perceive the conflict that is taking place on the territory of Ukraine since 2014 as internal conflict. So of course we have to first of all very precisely define that since the special operation undertaken by the Russian Federation on the Crimean Peninsula, that's it resulted in an annexation of of Crimea into the Russian Federation, we talk about an ongoing act of aggression of Russia against Ukraine, and Russia has violated numerous international law treaties, starting with the United Nations Charter, starting also with many different bilateral agreements signed by Ukraine and Russian Federation in terms of the cooperation, the neighborhoods, also different in terms of the Crimean Peninsula and the division of flats in Crimea between Russia and Ukraine. When it comes to the question of strictly of Donbas and the situation observed in the eastern part of Ukraine, we as international lawyers understand the situation as international armed conflict, even though the Russian Federation did not annex those territories of the so-called DNR and LNR as it was done with the Crimean Peninsula, but due to the possible attribution of the conduct of the so-called pro-Russian militants, the Russian Federation, we talk about the international armed conflict, of course, and I agree here with the ICC prosecutor that in numerous reports, annual reports, underlines the situation of the parallel international and non-international armed conflict which is taking place in the eastern part of Ukraine, but for sure it cannot be called a civil war like it is mentioned in the Russian propaganda in the policy of disinformation. So in that terms, international law is also a powerful weapon for the Ukrainian authorities to counter this false Russian propaganda. When it comes to the reintegration of Donbas, we have to remember that those two entities like DNR and LNR are the so-called protostates or unrecognized regime. They are beyond any kind of normative system, so they are not. They cannot be treated as subjects of international law. They are just illegal entities established as a result of the external aggression of the Russian Federation that have supported those pro-Russian militants in undertaking such actions. I have in my chapter I have underlined that their integration strategy in Ukraine shall be based on different pillars of transitional justice in terms of the post-conflict justice pillar of this huge and wide concept of transitional justice as such. First of all, we have to underline that in terms of the political negotiations, for instance, witnessed within the Normandy format or based on the political, not legal, political Minsk agreements, Minsk Accords, those entities are illegal. That's why all perpetrators of human rights violations and the so-called international crimes committed, including crimes against humanity or war crimes, shall be held responsible either before the relevant Ukrainian court, domestic court, or before the International Criminal Court. This is the first thing. The second thing, of course, we have to remember that international law gives a possibility to grant amnesties. Amnesties are prescribed by Minsk Accords, but according to the jurisprudence of different international courts and tribunals, amnesties, people who committed crimes, such crimes against humanity or war crimes, cannot be covered by amnesty provisions, so-called blanket amnesty. So, of course, Ukrainian authorities shall take into consideration the strategy of amnesties, but of course, excluding the so-called leaders of DNR and LNR and all other people responsible for the grave breaches of international humanitarian law and international crimes committed. And the last thing, I think, for now at least, the case of this regional diversity within the conflict resolution and the reintegration of Donbas as a policy. I would like to draw your attention to the possible, which is also from time to time mentioned in the literature, the possible establishment of Truth and Reconciliation Commission that can establish the truth about the violations and can reconcile people living on both sides on the front line. But, and to some extent, I see it as a good idea, but nevertheless, we have to remember that those kind of institutions like the Truth and Reconciliation Commission can also be used by the Russian propaganda to justify or to confirm in the Kremlin's eyes the internal character of the conflict. So Truth and Reconciliation Commission, yes, but in a sequence of, first of all, delivering criminal justice, granting amnesties to people that have just been involved in different hostilities, but without committing the most heinous crimes, and the possible reconciliation mechanisms as also this extra or non-judicial pillar of transitional justice. I think for now it's all from me. So thank you very much.
Okay, thank you, Tomasz. Before we proceed with the next part, I'll briefly introduce my part. My part focused on the domestic dimension of the ongoing conflict, in contrast to the part introduced by Tomasz. So the idea was to look at the domestic legislation in Moldova, in Georgia, and Ukraine, where we currently have Russia-sponsored conflicts, and then find out an extent to which countries understand ongoing conflicts and define contested territories in a similar and different way. So we found out that there are two very different approaches in Moldova and Georgia. In Moldova, the legislation is quite soft. It looks at the ongoing conflict and the contested territories as the ones with special status and provides for limited trade opportunities with these territories. So this approach was defined like a special status one. And if we look at Georgia, the approach is much tougher. Georgia considers Russia to have occupied Abkhazia and South Ossetia. Plus, Georgian legislation doesn't provide for any meaningful contacts between the country's controlled territories and the breakaway ones. And as a result, there is basically no real room for transforming the conflict in Georgia through fostering step-to-step contacts between the government-controlled territory and the breakaway regions. If we take Ukraine, Ukraine takes a hybrid approach. It uses both the special status and reintegration tracks of domestic legislation that sometimes contradict each other. There is a law of Ukraine on special status of guns of some territories in the east of Ukraine, and there is a law on reintegrating these territories. So the laws are very different and sometimes contradict each other. For now, while the Minsk process is not yet completed and experiences multiple challenges, these domestic legislation issues don't really impact the conflict resolution and conflict transformation process. However, potentially we'll find that there could be such impact, especially in case the reintegration legislation continues existing longer if the Minsk process will achieve significant progress. Also, on the broader arena, we made some contributions in theoretical terms regarding the role domestic legislation plays with regard to conflict transformation, finding that it's quite important. It sets a framework for negotiations, plus it can also introduce kind of red lines the government can't cross, or in case it crosses such red lines, it may then experience protests and mass discontent from the population. Plus, domestic legislation is also important in terms of letting partners know how the government shall approach conflict resolution and conflict transformation, and also sets the red lines for partners' efforts to address the conflicts and meet each other in the negotiation for without Ukraine, for instance, such as G20. So this was very brief about the domestic dimension of governing the Ukraine conflict and contested territories. And we'll proceed now with discourses, the discourses about federalization and decentralization in Ukraine. And I would like to pass the word to Nadia Koval, who worked extensively on the issue of federalization and the way it's presented in Russian and German discourses about what's happening in Ukraine.
Thank you, Maryna. Hello, everyone. As already Ani said in her introduction, I am working these years about a different framing of Ukrainian crisis, Ukrainian conflict, the conflict with Russia, both by governments and experts all around the world. And in this context, the idea of federalism, of federalization is of very big importance. And generally, my chapter considers the use of this idea in the strategies of the foreign actors. The reasons for the chapter was to put the whole federalization discourse in the perspective, because both its context and timing are of ultimate importance. And since 2014, it has long transcended the borders of the internal affair of the state. And it's currently widely discussed internationally, posing a very important question about the limit of state sovereignty. And this international dimension of supporting federalism in Ukraine, it can take the milder form of technical advice of financing decentralization priorities in the reform agenda. Or it can be quite blunt, demanding deep state federalizations under the threat of force or actual use of force. And in the case of such a vague issue as federalism, I've counted at least 3 different approaches that are used in the context of international politics. First, a foreign actor might press upon the country to adopt the federal structure as a means to influence its foreign policy. In our case, the neutral status of Ukraine regionally, in a very broad meaning of security, political, economic neutrality, either through some official agreements, which is less likely, or de facto, just freezing informally all the attempts of the European integration in its current state. Second option for this international pressure for federalism is supporting federal solution as a means to resolve the internal conflict. And in Ukraine's case, this is centered around the so-called political part of the Minsk agreements. And the Minsk agreements, as you well know, are now acknowledged internally and internationally as the main way to resolve the conflict. So we have federalism as a conflict resolution instrument. And third option is encouraging decentralization as a means of democratization and good governance in the general reform framework, which is also very important in Ukraine since April, let's say, 2014. And it turns out that the international political and expert discourse around Ukraine after 2014, federalism, federalization, decentralization, they suddenly become the most popular ideas of how to resolve the most of the problems of the state, how to achieve internal stability, how to implement a reform agenda, or even treating this as a first step to building the new regional, even world order, and finding a new place for Russia. And what is extremely important here is that in Ukraine's case, the use of terms which have very, let's say, precise meaning in scientific literature. Yes, we're speaking about federalism, federalization as a process of making the state from unitary state to federal state, and decentralization. Of course, these are very different concepts with very different meaning, but the meanings are deliberately confused, which allows to play on these 3 different aspects depending on the political aims of the player. This is not the question of synonymity, this is not the question of some personal preference, but this is a very tense political game around one of the key questions in the conflict. So if we look at the conflict, we can see that Russia generally advocates deep federal solution, and it's routinely underlined that the term is of secondary importance, and Foreign Minister Lavrov has endlessly said that, okay, guys, you can call this decentralization, that doesn't matter too much, but you should do 1, 2, 3, 5, which in reality, his demands correspond to deep federalization of the state. Ukraine itself, while acknowledging the Minsk agreement, concentrates predominantly on this decentralization reform agenda and denies political compromises on the unitary nature of the state. And Germany too speaks mostly of decentralization, though it supports elements of the federal solution as conflict resolution instruments as well. So basically my chapter is devoted to deciphering the aims, use and discourse of two key players in the conflict. First is Russian Federation, which has put the federalization of Ukraine in the center of its strategy and effectively launched this federalization related discourse internationally. And the second state is Germany, one of the most important international players involved in the conflict resolution, a state with a long tradition of federalism internal, which is receptive to federal-related instruments in its conflict resolution strategy and actively supported decentralization reform in Ukraine. And this all is very described in big detail in the chapter. Just to say two words, if we look on Russia, we will see that mostly Russia uses this foreign policy decentralization discourse, like the idea of employing decentralization and federalization internal to influence the foreign policy of Ukraine or the regional foreign policy. And especially after 2015, it presses on federalization as a means of resolving internal conflict. When as to decentralization, Russia is definitely non-interested in none of that and considers this to be contrary to its interests. If we take Germany, Germany is one of the biggest sponsors of decentralization reform. She has invested much money, influence, and political support into the Ukraine's decentralization. And of course, Germany is actively involved in the Minsk-centered let's say, negotiations and tries to move the conflict resolution forward. And here I will stop and encourage you to read the book. Thank you.
Thank you. Okay, thank you, Nadia. And now I'll pass the word to Yaroslava, who will continue with decentralization and the threat state in terms of national security.
Thank you very much, Maryna. Well, first of all, thank you very much for the invitation. I'm very happy to be presenting the book here with you all. So in my chapter, I examine the extent to which the ongoing decentralization reform in Ukraine has been effective in curbing Russian-sponsored separatism. So I believe to some extent I play a little bit devil's advocate in my chapter contribution, because my starting point was to challenge a widely accepted premise that the empowerment of lower levels of government through the diffusion of political and fiscal powers inevitably contributes to dismantling existing avenues of rent-seeking at the regional level, thereby hindering Russia's ability to drive wedges into society. And a related sub-argument, let's say, is that the newly created territorial communities as part of the reform, because of their smaller territorial scale, they would prevent the Kremlin from carving out entire regions for the creation of separatist projects of the sorts that we witness in eastern Ukraine. So this was my starting point, and to challenge these arguments, in my chapter I presented empirical evidence that fundamentally contradicted this premise. So in particular, I focused on activities that were intended to subvert Ukrainians' constitutional order from within, and these were specifically so-called fake territorial communities and special economic zones. What these entities had in common is that they preached populist ideas of self-government, but fundamentally they appropriated and twisted the vocabulary and the tools that were derived from the decentralization reform to put in place a parallel system of power. And if we looked more specifically at each of these phenomena, what these fake territorial communities did is that they operated in parallel, but in opposition to the official territorial communities that were being established as part of the reform. And what was happening on the ground is that they were so-called self-proclaimed representatives, upovnovážení, that's how they called themselves, or registrators, registratore, who unlawfully acted on behalf of entire villages, if not even cities, through illegitimate practices that involved the appropriation of state authority. And to give a few examples, they would issue, for instance, so-called passports of persons, which allegedly gave immunity to Ukraine's laws, and also granted tax exemption to whoever held these passports. And these passports would be issued at the same time with certificates to national entrepreneurs, narodni підприємці, who basically were people who ended up engaging in tax evasion. And these representatives fundamentally seized tax powers and diverted tax revenues from Ukraine's state coffers. Other common practices were issuing vehicle registration number plates, confiscated communal property, and occasionally also establishing local courts and law enforcement agencies. And to briefly mention the special economic zones phenomenon, basically these were cases where they were demanding regional autonomy, especially in matters of economic matters, and by doing so they risked consolidating trends that the reform was meant to combat in the first place. There is the concentration of power at the regional level. And what was interesting is that first, these phenomena basically touched all different corners of the map of Ukraine. So we saw, for instance, a special economic zone from Zaporizhia, Odessa, Zakarpattia, Dnipro, Kharkiv. So these were not phenomena that were concentrated in certain regions that we usually associate with secessionist sentiment. But the most interesting finding in my study was that all of these entities were systematically being established with the assistance of individuals linked to the NGO Ukrainian Choice, Ukraiński Wybór, which, as we know, is being headed by Viktor Medvedchuk, who is also the co-chairman of the pro-Russian party opposition Platform for Life. And we also know that he has close ties to the Russian leadership, Russian President Vladimir Putin, his godfather to his daughter. So we know that Medvedchuk has been a consistent advocate for federalization in Ukraine, portraying Ukraine's regional differences as this insurmountable impediment to the viability of Ukraine as a state, and presenting federalization as the only solution capable of keeping the country together and stitching these different regions together. And these entities were created also with the involvement of Russian security forces and occasionally also representatives from the anti-Maidan. It can be debated, of course, whether these entities were just self-contained, clumsy, and largely inconsequential destabilizing attempts, or actually they were symptomatic of systematic efforts to undermine Ukraine's constitutional order. But fundamentally, on the basis of this empirical study, the main takeaway was that the merging of the decentralization process with the request to grant special status to the occupied areas as part of the Minsk process indefinitely postpones decentralization-related constitutional amendments, including the institution of prefects. And this is a key point because the institution of prefects was meant to represent some sort of state oversight over the activities of local government bodies. And these would also be the officials that would report to the capital any case of secessionism or appropriation of state power at the local level. So we see that for as long as these final constitutional amendments are not implemented, there is a possible window of opportunity for the emergence of such secessionist experiments. And this basically led me to the second part of my chapter, where because of this link between the decentralization process and the request to grant special status to the occupied territories, I analyzed a number of threats to national security that I believe we would be facing if such autonomy were to be granted. So I think I'll leave it at that, and I'd be happy to delve more into detail in some of these during the Q&A. Thanks.
Okay, so thank you, Yaroslava. Today, unfortunately, the authors who focused on the positive sides of decentralization didn't manage to join us, but there were also some positive views regarding impact decentralization exerts on European integration, on modernization of Ukraine, on democratization, and so on and so forth. There are, however, threats, as you have heard, and sometimes hearing about threats is even more important than hearing about the positive sides. So now I think we should pass the floor to organizers for managing the Q&A, or maybe Donna.
Yeah, it seems to me that considering the time, it is perfect to move to the Q&A. Natalia, it looks like it's your time to manage as you're seeing the questions from our audience.
Yeah, thank you so much. Thank you so much for participating in our series today. And I know that you're all in different time zones. And again, Walla, thank you for joining our session today. Yes, we can proceed to our Q&A session, and please leave your comments either in our Q&A box or in our chat box. And while we're waiting for our questions, I have to say that just a couple of weeks ago, I had this opportunity and this pleasure to speak with Hanna and Maryna about the volume, and we were also discussing diversity and the concept of diversity, which is also in the title of your book. It was mentioned during this conversation that diversity is normally or usually perceived as something positive. However, during the conversation was mentioned that it can be misused and abused. So I would like you to comment on this kind of ambiguous attitude to diversity, which can be possible on the national, international, or local level, regional level.
Thank you. I will probably jump in because, as I remember, it was my answer to these. The idea is that in Ukraine, because of a lot of historical processes happening, not within the last 100 years, but much longer, especially in the border region on the west, we have quite a mix of minorities together with the majority population that are living in the compacts, and many of these people are perceived themselves also as the indigenous. And for centuries, we used to think about these territories, which is on the south of Odessa region or in the Carpathia region and many other places, as the territories of the peace and tolerance, as people used to live like this, no ethnic conflict. However, after 2014, we started to see how easily these diversity can be used for the negative. And first of all, it happened through the disinformation, through the information manipulation, through the gossips, through the different information operations happening there. So when very easily, through the just brief gossip, you could make the conflict or at least a very tension situation. And in this case, what makes the complexity of the problem that it can be both between the different ethnic groups living at the same territories. It can be between the periphery and the central government, because definitely, as in the classical books, we know that usually the ethnic can be the beginning, but it always other problems that would just add the snowball to these. But also we started to see how the Russian Federation used all this diversity, not only in terms of supporting Russian-speaking population, what is just a part of the problem, but very few of the foreigners know how Russian Federation also have been using the relations between Ukrainians and other ethnic groups to fire the problems, to exaggerate them or to use them. Especially it has been in the relations between Hungarians and Ukrainians, Polish and Ukrainians, Moldovans and Ukrainians. So they used all the opportunities, all the weak points. So we definitely think that diversity is the treasure of Ukraine, but at the same time, it is very fragile treasure that if misused can be easily just turned into the very, very big problem, not only in the east or in Crimea.
Thank you, Hannah. And your comments actually lead to another question about terminology. Well, please feel free to add to this question whatever you would like to. In Ukraine, there are a couple of terms, which are circulating right now, but the majority of the Ukrainians agree on these terms of occupation or annexation. During these talks today, it was mentioned that on the international level, the terminology is not that clearly defined. Let's take the example of Russia. In Russia, the annexation of Crimea is not accepted at all, and it is viewed only as reintegration. So I'm wondering how this diversity of different terms circulates in the international context, and how we can probably balance it, if it's possible at all, without falling into this situation with propaganda or disinformation as well. And I think, Anna, what you just mentioned also makes sense in terms of how different information is perceived in different countries, depending probably on different priorities. As disinformation is in Ukraine, but in the Russian context, for example, it's not disinformation. It's something that is perceived as true information, but again, that's quite questionable as well. So my question is about these terms which circulate on the international level, and what steps could be undertaken, if possible at all. I'm not an expert in this legal issue, to somehow balance the difference which is implied by at least these two terms, annexation and reintegration.
I will try to be brief, because this problem is both legal and political. So first of all, definitely we would agree that the terminology used by the international organizations such as the United Nations and the Organization for Security and Cooperation in Europe are that one that is the most important. So in the documents of these two organizations, as well as NATO and European Union, we have a very clear statement that it was the annexation. Why annexation? Because there was no agreement of Ukraine, whose territory that is, to give up these lands. So from this point of view, there is no contradictions. The fact of annexation, it is a neutral term. It is just taking the land without the agreement of the mainland. For Russian Federation, they prefer to say about the next step, because reintegration didn't happen at the same day as the annexation. There were few days in between. So definitely they don't want to use annexation, as it is something negative in their mind, especially that they like to make parallels with the Second World War, and their annexation is always bad. So they prefer to speak about reintegration, so to excuse the acts of them. But you can't find any other actors who are using this term. Occupation is definitely a different term, and it is much more complicated, because here we don't have the unilateral, or better to say, the single approach among the different organizations. And when you deal with the east of Ukraine or with Crimea, these terms are used in different situations or for the different periods of time. Because here, and that is probably better, I will give the word to our lawyers here, as occupation is what we used more in the political general term, but now with the first decisions of the International Court of Justice, we started to use the terms like effective management or effective ruling, and many, many other terms that give different nuances to the situation.
Thank you, Hannah. Tomasz, would you like to add anything to this?
Yes, thank you for giving me the voice. Of course, we have to remember that international law sets quite clear definitions on the terms that you have mentioned, like occupation or maybe annexation. Is not strictly a legal term, but it's a consequence of a violation of international law. So in that sense, of course, it also stands within the language of international legal order. I would say that in many even legal scholars that are not biased or paid by Kremlin, they talk about a different situation with regard to Crimea and to Donbass. Of course, the situation is different from that point of view that Russia has not annexed the eastern part of Ukraine. But if we use the possibility, which is given by international law, of the attribution of the conduct of the militants or non-state actors to the third state that is supporting, also in a military sense, in a financial sense, also by giving orders, instructions, we can say that yes, Russia is also responsible actions that are taking place still in Donbass, and I would agree that the situation can be named as a state of occupation also. Concerning the case of Donbass, not just the Crimean Peninsula, as it is stated, for example, in the reports of the ICC prosecutor. Ms. Fatou Bensouda does not mention the situation, does not define the situation on Donbass as a state of occupation, but I would agree for that kind of assumption. And just one brief remark, what can be done? I think the Ukrainian authorities, since the very beginning of the conflict, they started this, I call it as a judicial front line. They opened the judicial front line by triggering different international tribunals and courts, like International Court of Justice, European Court of Human Rights, International Tribunal for the Law of the Sea, and different courts of arbitration. And I would say that since at least up to date, in all of those situations, all of those cases, Ukraine is quite successful. So the binding judgments of such international courts stating that Russia possesses an effective control or is possessing or is a state of or is occupier of those territories is one of the, I would say, even more powerful weapon in trying to counter the Russian propaganda, since it's not just a political statement, but it's a binding judgment. So it shall be, at least in theory, executed, and Ukraine has also some instruments to push forward. And just one last remark from me, at least for now. As I mentioned before during my presentation, that this reintegration process shall be based on the transitional justice comprehensive strategy. I would like to add that normally in the situations of post-conflict or post-authoritarian states, transitional justice is a matter of internal policy of a given government. But in that case, we have to remember that we are facing, or Ukraine is facing, the international external aggression. So the use of international law shall be seen as a parallel to this transitional justice strategy adopted by the Ukrainian authorities. Okay, thank you.
Thank you, Thomas. Speaking about some methods or ways to resolve the conflict, in your presentations, Minsk process was mentioned many times. Recently, however, there are conflicting views regarding the Minsk process. Do you believe that it's still effective? Do you believe that it's still it's still working? And probably a couple of words can be mentioned about the Normandy summit as well. So how effective these methods are that we're taking right now? So please, Andriy or Yaroslava, Nadia.
Okay, I'm not an expert, especially in the Minsk process, but from the general point of view, it's absolutely obvious now that the Minsk process could be a way to stop hostilities and to create some framework for negotiation. But it has been stumbling for, I don't know, 3 or 4 years now, as was Normandy format. And this is a very problematic thing because Minsk has proposed a certain balance, some political concessions in exchange for some military concessions. But these concessions from each side are a bit of unacceptable. And each time when we see that they have a political player, for example, like we have President Zelensky now would like to move this balance, yes, who would like to move this Minsk agreement forward. It's actually a very difficult thing to do, because you can't move political process of the Minsk agreement format without damaging the national interests of Ukraine, which would be very difficult internally. And Russian Federation does not want to take its powers from the conflict region, and without the guarantee that it has the political solution within Ukraine, that it is up to its wishes. I would say that Minsk agreements were an agreement to free the conflict, but to resolve the conflict, I think we will have some further agreements. Thank you.
Thank you, Nadia. Yes, please.
Oh. If I may jump in. So, of course, I agree with the idea that the Minsk process has become quite controversial. So the debate is a bit split between those that say, yeah, it's obsolete, it hasn't been working for some time, so we need to just come up with a new platform, and others say it's the only tool we have at the moment, so we just need to work with what we have. But regardless of which position you stand on, my main issue is that there are some fundamentally incompatible positions within the participants in this process, and specifically, of course, here we're talking about Russia and Ukraine that cannot fundamentally agree on the sequencing, on the steps that would trigger the beginning of the end of the conflict. So do we implement first the political conditions that are envisaged by the agreement, or before the military ones? And so Russia, of course, first wants to implement the political ones for obvious reasons, whereas Ukraine is insisting on demilitarizing the territories first and then proceed with the political process. But for instance, this is something I'm focusing on in my PhD. And so when we talk about the long-term reintegration of these territories back into Ukraine, it's not just a matter on agreeing on the terms, which I completely agree is a fundamental point to start the discussion from, because our interpretation of terms filters our understanding of the reality on the ground. But however, currently during the occupation, Russia is pushing certain integration processes of the occupied territories within Russia in terms of the banking sector. You have Russian military, former military, that goes to schools and pushes all of these narratives about the Great Patriotic War and the Russian world. So when we talk about the long-term reintegration in legal terms, political terms, we have to keep in mind what has been happening on the ground these years, and how de facto the local population has been progressively being integrated into Russia on a number of policy issues. But fundamentally, Russia's interest is to have these territories reintegrated into Ukraine as the parent state in order to use these regions as leverage, as veto players against any Ukraine's integration into Western structures. So here there's also, we have to admit, a fundamental contradiction between Russia's long-term goals and its current activities. So sometimes I believe we have to be careful with understanding Russia's action in strategic terms. They actually might contradict themselves in what they're doing. But that's all I'll say for now.
Thank you, Yaroslava. I can but mention the language issue, because the language issue was one of those issues that were used for the escalation of the conflict and on the war as well. So could you please comment on the language issue in Ukraine? And I guess, Andriy, this question will be for you.
There was a little time lag in your speaking. Could you repeat the question for me?
The question is about the language issue. The language issue was used as one of the ways to instigate the conflict, and it was used in the escalation of the conflict. And what are the ways, why is it important in the first place to speak about the language issue in Ukraine?
Well, okay. don't think that I'm actually qualified to answer this question, because my focus of my chapter of my contribution was very kind of tilted into speaking about courts and politics, courts and management of language politics. So I'm not looking at this broader narrative making around or kind of trying to securitize this issue of language so much. What I would see, maybe between two languages, and this cleavage relies on two different camps, political camps that constantly trying to balance the political balance, language regime balance in one way or another. And what I also find very valid and very relevant to work on my while working on my chapter, that this cleavage, this focus, very often kind of precludes looking at other and accommodating other languages in a broader framework. Because when we speak about language in Ukraine, we imply this Russian-Ukrainian cleavage, and very rarely we think that, for instance, Hungarian or Romanian language is impacted by those new decisions after Euromaidan, with the new language law, with the new education law. And this is just a point that I wanted to make here. But maybe someone else is more qualified to answer.
Thank you, Andrei, for this comment. I think it's quite relevant to the situation that we have today, especially on the legal level, as we remember those banning laws in the 19th century against the Ukrainian language, and when the Ukrainians were not represented in legal terms. I think it really shaped our identity to some extent in terms of the 19th century, and unfortunately today we're still somehow trying to deal with those identity outlines, so to speak, that were formed in the 19th century, and the legal representation is crucially important. Do we have any other questions, Ani? Well, I would like to thank you all again for participating in our series, and again, thank you so much for joining us today, taking into consideration all these different zones. And I wish you good luck on your research. And again, I was very happy to meet you on Zoom, and I was very happy to talk again with Hannah and Maryna.